So Dave, if you can, just do me a favor, talk a little bit about the statute and what a consumer could do after bankruptcy to help get themselves back on track going forward.
Well, the statute we're going to talk about tonight is a statute relating to judgments in Florida. If you received a judgment prior to filing a bankruptcy, it's most likely recorded on the public records in Florida. When you have a judgment against you, it can cause a lot of problems with ownership of property, whether real or personal if they've recorded it with the state. But you can't transfer real property, you can't purchase real property without having some type of title issue if you have a judgment against your name. So you're going to have issues with title insurance, whether or not you can sell or get clear title to a property, especially in real estate. So Florida has a statute that's on the books. It's not really used too often in my experience, but when you receive a discharge in bankruptcy, if it's been over a year from the time you've received your discharge, you can petition the state court for a judgment deeming that judgment that you received prior to your bankruptcy as satisfied, which then it's clear on the public records that the judgment that was issued is now done and over with, and any title insurance problems or title ownership problems is resolved really quickly with a title search on the public records. Without having that petition done in the state court, you'll probably have to go through a lot of jumps and hoops and whatnot to prove that you listed that debt in your bankruptcy, that it was in fact discharged in your bankruptcy. And each time, one time may not be a problem, but every time you try to own or sell or do anything with that property, you're going to have the issue. So it just makes it nice and neat and cleans everything up so you can move forward without having the hassle every time you do something with your real estate.
And I think it's important because a lot of people out there who are filing bankruptcy have a judgment against them, whether it be from a credit card company, a medical bill, or any type of judgment. And if you don't clear it up, like Dave said, it's going to create problems in the future if you do go to try to finance a car or if you try to finance something. And it's a relatively simple procedure. You have to file a petition with the court. You have to go to a hearing, and then usually the judge's order. Once you get the judge's order, you file it in the public records, which takes roughly 10 seconds. And then you have that order saying that judgment is gone. So I think that's really good, and I don't think a lot of attorneys tell their clients about that.
Yeah, it's not really used too often because usually, the discharge, let's face it, the discharge will resolve the issue, and that's what you're doing in the state court, is you're proving to the judge that this debt, in fact, that had a judgment was satisfied in the bankruptcy. So the judge is just going to make it clear on the record that it has been done. Again, if it's a one-time thing, you have to jump through the hurdles. It's not a problem for most people because you'd have to do it for this petition anyway. But if you're going to do more than just one thing in your lifetime with real estate, probably you're going to do more than one thing with the vehicle ownership. It's going to just keep coming up over and over and over again, and better to jump through the hurdle once than just have to keep going back to this one issue every time.